And we'll get started with our next session on antitrust policy from the European perspective. I'm very excited about this one. Please welcome Lucia Bonova, Head of Unit of Digital Platforms at Directorate General for Competition at the European Commission, Prasad Krishnamurthy, Professor of Law at UC Berkeley School of Law, and Jenn Mellott, Partner at Freshfields. We're very excited to have you. Please give them a round of applause.
Hi, everyone. We are very excited to have with us Lucia Bonova here from the European Commission. I know we talked a little bit about antitrust law at the beginning of the day with Chair Khan from the FTC, but today we want to talk a little bit now about what's happening on the other side of the pond. So we're very fortunate to have Lucia with us, who in her 15 years at the Commission has really done it all. She has headed the merger unit that looks at mergers in the telecom and post and other sectors. She has been in the cabinet of Commissioner Vestager. But Lucia, I want to start off by asking you about your current post at the EC, where you are the new head of the unit that is responsible for enforcing the new Digital Markets Act. And so we do not have this act yet on this side of the pond. I think this morning we heard Chair Khan say that we are sort of in the US, the FTC is humbled, I think she said, by the laws that Congress has given it. But you in Europe have been gifted a new regulation to look at and enforce. So can you start us off a bit by telling us, where does this DMA come from? What is it intended to do? How does it fit with existing competition law?
Thanks, Jen. And I should start by saying that I'm very happy to be here. I should say humbled, but it's too much of LinkedIn. So I will just say I'm happy and excited to be here. So thank you for having me. So yes, it's an interesting relationship between the DMA, how we call it in Europe, the Digital Markets Act, and competition law, because I think that's about the only situation where it's okay to be both the mother and the cousin at the same time. So DMA was born from competition law. And DMA was born because we had quite some antitrust cases where we've seen that there are some systemic issues in certain markets and repeated behaviors. And of course, the problem with antitrust enforcement is that each case is separate. And you each time have to start from scratch and do the case, new analysis, new facts, investigate the effects, looking at efficiencies. And that, of course, takes time. And it's not very efficient when you know what you're looking for. And so we thought that the market was ripe for regulation. And of course, that has its benefits because the regulation, as we set it, is ex ante. And DMA essentially tackles these behaviors in a very surgical and targeted manner because it's a horizontal regulation, but yet very targeted in the sense that it regulates a number of companies, large companies, the gatekeepers, as we call them, which are indeed in a position where they act as an important gateway for business users to reach end users. And it also applies in a number of set limited market situations. So we call them core platform services. So you would have, let's say, search, you would have browsers, operating systems. So all of that, the DMA is what it is, nothing less, nothing more. So it's extremely focused. But then, competition law is still also a cousin because it remains in the game. So it's kind of a complementary tool. They act together. So of course, where it's a known behavior in one of these situations, the DMA will do the trick. But the competition law will always be there to address the delta, the behaviors, because as we know, gatekeepers are very innovative companies, including when it comes to antitrust issues. So competition law will be there to tackle the new situations and also, to investigate them, because that's a kind of good policy making, that first you see whether it's kind of a wide problem before you start regulating.
So how do you see the enforcement mechanisms that have been developed by the EC for the DMA, the Digital Markets Act, how do you see them interacting with those of other countries who might think about developing their own Digital Markets Act or their own competition systems that look after these practices? Right now, is there any kind of communication that's taking place? Do you think that the future will hold some greater harmonization? And then kind of lastly, when the EC is acting in this space, does it think of itself as a policymaker for Europe, or does it also think that it's having a global impact? And if it's having a global impact, like how do you think about that different dimension?
So I'm not going to say anything surprising that digital platforms are global, and the challenges which they raise are also global. So it's true that Europe has been the first mover in this space. It's not surprising that it's the regulation where Europe is the first mover, so that we are very good at. But it's also, widely known that there are other jurisdictions looking at similar laws, because I think everyone is realizing that something ought to be done, and including on this side of the Atlantic, but not only, it goes around the world. So we will all be looking at this handful of companies and trying to regulate them. And ideally, of course, it would be done in a kind of consistent manner. So I think it would be a kind of perverse outcome if now everyone started to do something else. I mean, there will be different approaches to this big question, but I mean, fundamentally, I think we all try to address the same type of issues, problems, and behaviors. So what is also good news is that we have frameworks for cooperation which exist in antitrust. I mean, of course, DMA is not antitrust, but we are building on these cooperation frameworks, which we have with the US and with other countries, both bilateral and multilateral. And we continue cooperating and exchanging because, these regulations will interact between each other, and this interaction will have to be managed, I think, for the benefit of everyone. And to your question, whether we are regulating Europe or the world, the truth is that, I mean, of course, we regulate only Europe, and also the way the regulation is actually structured, it always starts with the users in Europe. So, we need to designate these companies first, and they need to have users, both end users and business users in Europe. So we are looking at really those that have entrenched position in Europe. But it will be interesting to watch how the gatekeepers will approach this compliance, because this is a new situation for them, and they will have to comply with Europe, which is not a small market. So let's see whether it will have kind of a positive extraterritorial effect, in the sense that it's not worth it to have a business model for Europe and a business model for US and business model for Australia or China or Japan. So I think everyone is watching. I think we are a test case. So we are the first movers. We are on the front page, but also there is a pressure because we have to make it work.
Yeah, and I just want to pick up on this point you raised about cooperation, because of course you're right that there's a long history of cooperation in how we enforce say merger control rules or monopolization and dominance rules. With respect to the DMA, we're looking more at cooperation maybe with respect to the laws themselves and how they get scoped and what are the actual words on the page. Is the EC cooperating with other countries on their efforts to actually draft up a law, or are they just more kind of watching with interest?
Well, I mean, we have DMA, so it's more the others are watching. I think it's a fair thing. Everyone wants to see, and there is this curiosity. How did you do it? How did you approach it? Are there other ways? UK has done is doing their own approach. They're looking at it slightly differently than we do. But I mean, fundamentally, we speak to each other. So I think it would be surprising to see now something completely different coming in one of these jurisdictions. So I think on the margins, there may be some differences how you tackle this, but I think fundamentally, I think that these regulations will be very, very similar.
Yeah. So it's early days. You have this new regime, gatekeepers will be designated, and then we're going to get into compliance. And I read something that suggested that the DMA is self-enforcing and the rules are so clear-cut that companies will just read them and know how to follow them and everything will be well, which I think those of us who work in this area and look at the regulations know that's not always the case. And so I'm interested to know, as this plays out, what do you see successful enforcement and implementation of the DMA looking like, assuming it's not you sitting on a beach sipping a cocktail, because it's also clear that we understand it and we just enforce.
Yeah, I think we read the same article, Jen. And of course, I read it before I took this job. So, they told me it's easy, it's not going to be hard, it's 9-to-5 job, it's all self-executing, there will be a handful of specifications, but by and large, it's pretty clear. Well, as often is the case, the reality turns out that these things are actually pretty complicated. And so we are in the designation phase, or pre-designation phase, we can say, because the regulation will enter into application only actually next week. And we are now engaging with the gatekeepers to read the DMA together, because there's no surprise that we don't necessarily read certain provisions in the same way. And you are asking what the successful compliance will look like, and it's $1 million question. And I ask myself, really, how does the success look like? And I think at a very high level, what I can say is that, I don't know whether I should say that, but I do not expect miracles, or at least not overnight. But what do I hope for is that we are on a path with these companies, hopefully, that will cross the Rubicon soon and realize that they have become regulated entities, and that the markets will move, the markets will change, they will become more contestable. We will see emergence of new players, new business model in these areas where it's been entrenched. And I also like to think that it's such a shock like this one for these companies, also an opportunity for the companies to reinvent themselves and to come with new business models. So I would say a success will look like if, let's say, in a year or two, I'm not going to say that we are going to have another Google search engine or of the same, let's say, success, but that we've seen some entries and new app stores emerging, and hopefully that bringing more competition in the game.
And if you don't mind, I want to ask just one more question about the DMA. I think looking around the room, I see some people that are at companies that may be designated as gatekeepers and are in that process, but there's probably a lot of folks in this room who are customers, suppliers of the potential gatekeepers, or interact with them in other ways. And I'm curious if you think those folks have some role to play in compliance efforts. And there's no formal complaint mechanism under the DMA, but is that something that you envisage in kind of your day-to-day ongoing compliance once this is all,
yes,
running?
No, but thanks for this question, because there is this kind of a myth that I have to debunk, is indeed we don't have this kind of formal complaint mechanism, but that's something that you have to understand in the kind of European context, because what that means is that we have that in the antitrust. And that means that whatever complaint comes in, we need to investigate, we need to address, we need to issue a decision. There's just lots of bureaucracy about, a complaint about the collusion between funerary services in the city of Milan. So basically, we wanted to depart from that system, but that doesn't mean that we do not listen to third parties. I think to the contrary, and I think it's super important, because we do it for them in a way. This has to work for these business users. So we are, and I think that it's informative in two respects. One is really to identify where the problems are, and because there's one thing that we know, but as we know, that there may be an obligation which is self-executing or less so, but there's all kinds of dark patterns which may be put in place, which we don't necessarily see or are not aware of. So we really want to hear where are the issues, and also we are engaging already now actually actively with potential beneficiaries and other stakeholders with the possible compliance solutions, because these compliance solutions need to work in practice, both for the gatekeepers, so that we also engage with gatekeepers. It has to be something that works in their business model, and it has to be something which brings benefits to those we are trying to boost or to protect. And we organize workshops. So I don't know whether you heard of those, but it's also like a big event with over 1,000 people connected, which are on specific obligations or issues. So we had one on self-preferencing, we had one on app stores, we had one on interoperability. Now next week we have one on data obligations. So you can register and listen in. So this is really a dialogue we are trying to kind of moderate between the gatekeepers and the possible solutions.
So as an academic, I'm often less interested in what jurisdictions do and more concerned that they all do something different. So that then there's some possibility of study. And here there really is. So one thing that I found to be really different from the standpoint of US antitrust law are the affirmative obligations that the DMA places on the main platforms to not either favor their own complementary products or services or prohibit or exclude those of other parties. It's a much stronger requirement on vertical interaction or complementary than exists under US antitrust law. And so I was interested in your thoughts on how you think enforcement of those rules is going to develop over time, if there are particular practices that you have your eye on, if you're able to say something like that, or ones that you think might be of concern in the future. And I raised an additional kind of economic point, which is that within economics, it is understood that an incumbent firm with market power can win competition for complementary services without having to exclude its rivals, simply on the basis of its deep pockets. And I was wondering if you were also interested in enforcement of that particular issue, that exclusion that happens without direct exclusion, but nevertheless has a market dampening effect.
Yeah, so I think you're looking on precisely our first workshop on self-preferencing actually focus on this question. To make it clear, DMA does not prohibit or even regulate all forms of self-preferencing. So we have the DMA deals with, let's say, two forms. One is self-preferencing in ranking. So everyone knows which antitrust case is the mother of this provision. It's a Google Shopping type of case. And the other scenario is self-preferencing on the basis of use of data. And that would be more kind of, let's say, Amazon Marketplace situations. And we know that this type of, from our antitrust cases, we know that these type of behaviors are harmful because they are kind of allowing the incumbent to, or the platform to undercut its rivals. And it's extremely difficult then to get in. And so the DMA actually sets the ground for this type of self-preferencing situations. Then there may be others, but if those arise, then we would have to really go through an antitrust case, because this is really two limited sets of situations where we know that this type of self-preferencing is harmful. There is many other types of self-preferencing which we haven't studied through antitrust case, and that also that's why we have this tool still at hand, which will allow us to, if there are facts, to look into whether there is other type of self-preferencing, including the one you are mentioning. So we haven't looked at those specific cases yet.
We also wanted to make sure we use some time to talk about mergers as well. I also want to maybe make a small point on this. I happen to be a member of the California Commission to review state antitrust law, and I'm on the mergers committee. And so we are to draft a report on how state antitrust law could be reformed. And I believe there's probably a lot of expertise in this room that I could learn from. So please contact me after the talk, or you can find me easily on the Berkeley website.
All right, no more plugs, no more plugs.
So it's for the public interest. But on this topic of mergers, so there's been an impression in recent years, I think broadly held across the major jurisdictions, that merger enforcement has gotten tougher. And so we were interested in your views on whether that's the case, and if so, why? If not, why not? And then even more broadly, how maybe people think that because the nature of the mergers are different firms, different industries are raising different types of anti-competitive concerns. And as much the response is to that change as opposed to any sort of greater or lesser degree of scrutiny.
Yeah, it's a good question. So I will speak clearly for my jurisdiction. I think that anyone who is following our activity we would rather say that we've been consistently, I don't know whether aggressive is the word, but being consistently intervening in cases. We've been also criticized for being actually overly interventionist. So I would say that in Europe we have, and also the data show it, that when you look at our intervention rate, it's very stable over time. But you raised a very good, and then I should say that I think that this kind of perception comes from the fact that some other agencies don't have the same starting point. So if you were under enforcing and you start enforcing, then you look as aggressive. And then in Europe, of course, today is the right day to speak about it, but you have CMA, which is a new agency. And when you're a new agency, you don't really have the track record. So it's very difficult to say whether they are being more aggressive than before. But you raised a very good question about the type of the cases we see. And I think that's maybe, it's a little bit kind of mixing of the narrative, because one is the intervention rate, but the main question is what type of cases we are intervening in. And if you look, let's say when I started 15 years ago or so, you would see these big industrial murders, typically horizontal cases, the typical theories of harm, of creation of reinforcement of dominant position with a typical structural remedy, and that's it. And it's true that if we were now looking at these statistics and the data in a kind of more granular manner, and you would look at the cases that we've been intervening in lately, you see more and more conglomerate cases and vertical cases. And these are very different cases because you are no longer looking at the cases when someone or the incumbent is buying a copycat. You are looking at cases where, in the tech industry, where you're in a reinforcing ecosystems, the data accumulation cases, where the harm comes actually from something very different. And I think Google Fitbit is a good example of that, because it might have come as a surprise that we intervened, but it was a very specific theory of harm, which really came from this data accumulation. And you have the kind of furious harm about the decreased interoperability, which go into really all kinds of dark or not so dark patterns that gatekeepers may have, or large companies when they acquire a kind of different company which fits in their ecosystem. So it's very different cases. That is true, and that maybe can be perceived as aggressive enforcement, because it's true that 10 years ago, you don't do this case when you're a crane company and then now you acquire forklifts. It's a complementary products, but the portfolio, you can serve better the customers. And so this would be the comparison between Google Fitbit is like crane and forklifts. Like, what do they have to do with each other? But yeah, it makes sense in this market.
It's interesting because I think when I started practicing competition law, we would sit here in the US and say, oh, what is the EC doing? You have cases like Dow DuPont that felt like a departure from what had come before. And we would sit here and say, well, the DOJ and the FTC are so sensible, and what is happening over in Europe? And we don't say that anymore. So, one area where I think the EC approach in recent years has clearly changed is with respect to jurisdiction and how you're using Article 22. And for folks who aren't initiated in the room, Article 22 is a mechanism by which the Commission can have cases referred from countries within the EU so that it can look at cases that have an EU component. And historically, this mechanism was used in cases that were reportable in the country that referred it. So you file your merger in Germany, they say, actually, we think the EC should look at this because it has a European-wide dimension, and they refer it up. But that all changed last year in the Illumina Grail case, where this transaction was referred up to the Commission, even though it wasn't reportable in any member state. And in fact, Grail had no sales in Europe whatsoever. And this kind of change in approach where you've actually put out new guidance on how you think about Article 22, it creates really a lot of uncertainty for companies when they're thinking about, how do I draft my SPA? What conditions precedent do I include? What does my timeline look like with this risk hanging over my head that this crazy thing could happen that 2 years ago I would never have thought about? What advice do you have for companies that are trying to navigate what the Illumina Grail case and the new Article 22 guidance from the Commission actually means?
Get yourself good lawyers. That's in short. No, but it's true. We recalibrated our approach. So, I mean, there is nothing to hide, but maybe a little bit step back why we have done it. Because precisely when we enacted the merger regulation, as many people know it, we were reasoning in terms of thresholds, turnover thresholds, how much sales you have in Europe. If you have sufficient amount of sales in Europe and in member states, then you have European dimension. And this really, by and large, reflected the cases we should be looking at. But a little bit linking to my previous point, the nature of cases changed. Because now you see these transactions where you acquire companies much earlier on, which are nascent, which have no turnover whatsoever, these innovation cases, and we see the problems. And so basically what we've said is that we have this tool, which we haven't been using, but we should start using it so that we can call this transaction in. And there were the whole debate in Europe whether we should revise the merger regulation and come with some kind of a new threshold, which would be kind of tackling this, like size of the transaction or whatsoever. And we looked at it, and when you reason in terms of thresholds, you will always find the odd case which somehow doesn't fit in your new threshold. So this is again kind of a very targeted and surgical solution, because it allows us to look only at the cases which we should be looking at. So it's not kind of a horizontal notification with a new threshold, and now you have 300 new boxes of papers in your office every year. It's really targeted, and we took jurisdiction in one case, Illumina Grail, in 18 months of the application. So that shows how effective it is, because it really allows us to look at this subset of cases which are problematic. And I agree with you that it's new. It's new for the companies. It's new for the lawyers, because now they cannot predict what are these guys going to do. That's why we have also issued our guidance. There is Q&A. So I would say get in touch early on, see whether this is a case which is of interest. But I think a good lawyer, like those who are in the room today, I think. Will be able to kind of guess fairly well which cases could be of interest to the Commission under this new guidance. And if not, you just call me.
So now this is going back to the Digital Markets Act. Again, another area of this act that I think for American antitrust lawyers is really something to look at is the standards that are being demanded or put in place for interoperability potentially from the platforms. So for an American antitrust lawyer, if one thinks about the treatment of antitrust law and interoperability, there is one doctrine called the Essential Facilities Doctrine, which is very rarely invoked, not for decades. And the only area of law in which we have substantial rules that make competitors deal with one another is in our Telecommunications Act. And we do that through a rulemaking regime that is really quite detailed, and it has its own administrative overlay. So what struck me as being not very self-executing in the DMA is that kind of interoperability is being potentially imposed on platforms with respect to rivals or even with respect to complementary producers. And so I'm curious as to how that is plans to be enforced, whether rulemaking is something that can happen in that space, and just in general your thoughts.
Yes, and you are right. It's not self-executing, and that is also why it's in a separate article than the other obligations. So it's a very clever tool. So I mean, it concerns really the interoperability in messaging. So again, it's something very specific And so we have this Article 7, which says this is the objective, and there is a possibility for gatekeepers to, or also for us to issue a specification decision, so to go really into how this should be done, because obviously, I want to interoperate, but if you don't want to interoperate, and interoperate how? Is it like my standard, your standard? Because if we apply mine, it will be less costly to me, but more costly to you. So there is this possibility of these specification decisions. I mean, of course, when we're doing this, that's kind of an obvious question, right? Should we have some kind of standard? And I think it's a very relevant question. But I think the DMA consciously decided not to do that. I mean, why? Well, the first reason is that, okay, what standard? It's not for the Commission to really, be a standardization body. Not yet. We may get there. And second is the inherent timing aspect, which is associated with this type of exercises. So coming up with a common standard in an industry like this, it's extremely lengthy process, and we wanted to have something quickly. So of course, if the industry somehow converges over a standard, we will take that into account in the application of this obligation. But at this stage, it is not our intention to become a standardization body. We already have enough on our plate.
So Lucia, it's getting late in the day. We have, I think, one panel standing between us and cocktails. You are probably jet lagged from flying over from Europe. And so I think it's a good time to ask you a deep philosophical question.
Oh my God, not about the book, not about the book.
So, when we talk about the DMA, the way merger enforcement has been trending, we have, for example, to the situation Prasad just raised, you have situations where interoperability just becomes so difficult to deal with that a company says, I pull this product off the market, it's just not even worth it for me to offer it if I have to do all of this. Or, in the merger world, that enforcement gets so aggressive that companies just say, I'm not going to do this transaction. Or, very relevant for folks here in the Valley, that startups say, God, it's actually a lot harder for me to get funding because I'm closing off all these strategic acquisitions that I could do as an exit because they're all called harmful to innovation, competition, or killer acquisitions. And I'm curious if at the Commission, if you ever kind of think about this question of whether there's a risk that too much enforcement actually does the opposite of what it is you're trying to do, and removes innovative and important products from the market that consumers like, or makes it difficult to do transactions that actually would be useful and lead to investment in new startups and things like that.
Yes, we think about it surprisingly, but we do.
That's good.
But this is, of course, this is always the question, whether to regulate or not, how to regulate, when to regulate. These are exactly the questions you are trying to ask, because you do not want to kill the innovation, you want to promote the innovation. And when we were thinking specifically about DMA, there are various models we were exploring. And we landed with this very targeted model precisely because of this, because we don't want to kill the innovation, we want to promote the innovation, and we really hope that this is going to happen with lowering the barriers, increasing the contestability of the markets, with gatekeepers changing their business models, with new business models emerging. And maybe the facts will prove us wrong, but I really hope not. But of course, if you reason like this, then you should never regulate. But I'm pretty sure that there is academic theory about when to regulate and not.
There is also on when to ask philosophical questions. So I have one. This is based on a conversation we were having earlier as we talked, and it's. I noticed there are a number of younger lawyers in the audience, which to me means people who look younger than me. And we had talked about, I said, do people go from practice in front of your commission to serving in a role? And you had said, no, generally no. And that it was a much more siloed relationship between the regulators and and the bar and the parties, and that's very much less the case in the United States. This is a plug for younger attorneys here to go work for an agency at some point.
And then come back to private
you had
practice.
some broader thoughts on those different systems, and so I wanted you to share those with everyone.
So how many people are connected? We said. So we'll see what kind of answer I'll give. Yeah, I think it's cultural in a way. You know, in Europe we have this, at least in the Commission, it's kind of an old-fashioned public administration French model where you grow up, you go to university, and then you sign up, and then you die there. And maybe in between you change from one ministry to another, or at least you change the corridors in your own ministry. So this is the type of model, and there is also this kind of whole obsession about the integrity and independence of public service in Europe. And I personally always wondered why, because it kind of completely disregards the integrity people have in them. So obviously there would be benefits with the revolving doors to see people, to the kind of the state-of-the-art knowledge, and to know what the company is. Because of course, if you join the Commission at the age of 25, by the age you're 40, it's not the same world than the one you left 15 years ago, and you have never set the foot in the company, so it's not always good. But this is what it is. I really hope I'm not going to die there. It's not that I'm looking for employment offers or anything, but not doing that. But that's how it is. But it's true. It's very cultural, and you see that both models work. So I don't know why we are so in Europe so scared of sending people out and letting them to come back.
Yeah. Well, with that, I think we're at the end of our time. Thank you so much, Lucia. It was really great to hear about Europe.
Thank you.
I think Lucia's email address is publicly available if you want to send employment offers her way. Thank you all.